Before we get started, please go over to Amazon.com and grab a copy of my book, Education and Justice. If you have an African-American son in public school, you need this book because I teach you the many ways that public schools mistreat African-American boys and what you can do to help your son. So go over there and get your copy immediately. I am going to share with you a really huge police deadly force case involving a young black man. This case is so huge, it will impact the way courts across America will handle deadly force cases involving African American men and, of course, women. I'm actually amazed that you probably have never heard of this case. It was just handed down a couple of days ago. And that's why I try to tell you not to rely on white-owned media, both main media and social media, to inform you of matters that are critical for us African Americans. All right, so let's get started. 5 seconds. 5 seconds. That's how long it took for Ashton Barnes to go from a traffic stop, a simple traffic stop, to death. And then 2 seconds, 1, 2. That's how long Officer Roberto Felix Jr. stood on the door sill of a moving car before he shot and killed Ashtian. For years, the courts have said that's all that mattered, those 2 seconds. But this story in the Supreme Court's recent ruling proves that justice demands more than just 2 seconds. That a young black man's life matters more than a mere 2 seconds. So this is the story of Ashton Barnes, a young black man who died during Obama's second term, and his mother, his loving, dedicated, determined mother, fought his case and won it during Trump's second term. That is 9 years. He was a 24-year-old young black man. Think about how young he was, 24 years old. I literally have shoes that are older than Ashton was. Now, key to this case, he wasn't a criminal. He wasn't fleeing a crime scene. He was not armed. He was not a gangbanger. But even if he was all that, his death was unlawful and needless. So Ashton was driving a rented car to pick up his girlfriend's daughter from school. He loved basketball. He loved to play video games. His family says he was full of life. That day, April 28, 2016, that's over 9 years ago, Houston traffic cop Roberto Felix Jr. pulled Ashton over for unpaid toll violations. You heard it correctly. This whole thing happened over unpaid toll violations. Reminds me of George Floyd being lynched over the allegation that he was trying to pass a fake $20 bill. Anyway, that traffic stop ended Ashton's life. So what happened during that stop? Well, I want you to see for yourself. I'm going to play the Dashcam so we can see, literally look at what happened. Let's look at it now. Now, I intentionally did not play the audio because what really matters is what you see. That really tells the story. So what you see is Officer Felix. He claimed he smelled marijuana, though there were no drugs found in that car. Ashton had turned the car off. The officer asked Ashton for his driver's license. Ashton said he didn't have them, but he offered to let the officer look in the trunk for his paperwork. The officer told Ashton to get out of the car. However, Ashton restarted the engine and you saw him pull away. Instead of stepping back and allowing Ashton to go forward, the officer jumped on the car's running board, the door down where you step into the car. He jumped up there instead of just letting Ashton go. And then he pulled his weapon, and in those 2 seconds, he shot Ashton twice. Ashton died before the paramedics arrived. Now, for many people, that is the end of the story. Ashton got what he deserved. He shouldn't have pulled off. And people think that way because they don't value black life. If cops killed a white person under the same circumstances, people would not be so quick to excuse the officer. Besides, and I'm a practicing attorney here in Texas, attempting to escape is a misdemeanor in most circumstances. It is a low-grade felony, however, if you try to do so in a car. But most people get probation for that. Of course, that depends on other circumstances. And for the record, Ashton should not have pulled off. I'm not in any way condoning him pulling off. I tell people all the time to try to de-escalate police encounters, not escalate them. So absolutely, he should not have pulled off. But it still does not justify that officer shooting him dead in 2 seconds. Unfortunately, his mother, Janice Hughes, sued the officer and Harris County, the officer's employer. Unfortunately, after some litigation, the lower court, dismissed her case. Harris County filed a motion for summary judgment. The judge granted it and dismissed the case. Now, why? Because of a legal doctrine here in the Fifth Circuit called the moment of threat rule. This rule was created by the Fifth Circuit, one of the most conservative courts in the country. It has currently 15 judges, active judges, and 5 of them are Trump appointed. Now, this rule, it boxed judges in, and it forced them to consider the exact precise moment that the officer used deadly force. And in this case, it was 2 seconds. The 2 seconds that began when the officer jumped onto the door sill. So he literally created the threat when he jumped up on the door sill. He could have and should have, and I'll explain this later, allowed Ashton to ride off. So this rule did not allow the judge to look at when the cop actually jumped up on the door sill and events before that. The court was bound to look only at the seconds, 2 seconds, when the officer fired his gun. Not the fact that he jumped on the car creating the dangerous situation that he then used to justify shooting Ashtian. That's critical. Again, the judges in this case couldn't look at whether the shooting could have been avoided, whether the officer should have or could have done something to prevent the shooting. No. The rule confines the judge only to look at the precise moment the officer believed he was under threat. And that rule became law in Texas and Louisiana and Mississippi. In Ashton's case, once again, and I don't want you to forget this, it restricted the entire case to 2 seconds. So you got to ask yourself, how did this rule survive even though it violated Supreme Court precedent? So let's go deeper. Let me explain the law to you before this case. In 1985, the United States Supreme Court decided the Tennessee v. Garner case. I did a video on that case. Go back, it's a couple of years old, but it's still relevant today. And the case basically says that the police cannot shoot a fleeing suspect, even if the suspect is a felon, unless the suspect poses a substantial risk of death or serious bodily injury to the officer or to someone else. That was not the case in this situation. Now, the case also says that courts must consider the totality of the circumstances, not just the precise moment the cop felt threatened, but the totality of the circumstances. And again, the precise, exact moment that this cop felt threatened only lasted 2 seconds. Ashton's complete life whittled down to 2 seconds, which was the time, again, the officer jumped on Ashton's car's floorboard until he shot Ashtian. And the courts could not consider anything else. And had this officer followed the Tennessee versus Garner case, he would have done what? He would have allowed Ashton to drive away. They could get him later. After all, it was only about a few dollars, maybe a couple $100. But was all that worth whatever those tolls were? Just let him go. There was no evidence that Ashton was armed or dangerous or any of that. So he should have allowed him to go. So the question then becomes, why not? Why didn't he? Why didn't the officer let Ashton just ride off? Well, these officers are trained in the police academy, right? So they learn these cases that I'm talking about. They learn what these cases allow them to get away with and what they don't. So the officer definitely knows that Tennessee v. Garner says you can't shoot an unarmed fleeing felon unless he poses a substantial risk of death or serious bodily injury to the officer or to someone else. That was not the case here. The facts did not support such a finding. So why did he do that? Because these officers know quite often they can get away with almost anything. And that has to do with another case that qualifies the Tennessee v. Garner case. It was handed down in 1989. The case is Graham v. Connor, and it gives cops an out. Okay, it says essentially that you shouldn't second guess the split-second decisions that cops have to make. And so that case would say that Officer Felix did the right thing. He was justified in shooting Ashton to death because he made a split-second decision in a dangerous situation. Although he precipitated the dangerous situation. Ashton driving off, that did not create a dangerous situation because the car was going forward. It wasn't in reverse. There was a lot of room between the officer and the door of the car and the car itself. So driving away from the officer posed no danger to the officer. It's when he jumped up on the flashboard of the car that he himself created the danger. Anyway, the Graham v. Garner case that says you got to respect and you can't second guess, you can't Monday morning quarterback officers' split-second decisions, that gave the Fifth Circuit cover to create the infamous moment of threat rule, which restricted judges to considering only the moment the cop fired the weapon. And the Fifth Circuit came up with this rule despite the fact that the Tennessee v. Garner case said, look at what? The totality of the circumstances when cops use deadly force. Yet the Fifth Circuit, an extremely conservative circuit, created this rule despite the Tennessee v. Garner case saying you can't shoot unarmed fleeing felons unless they're dangerous. They hooked themselves to the Graham v. Garner case, which says you can't second guess officers' split-second decisions. They used that to create, again, this infamous, dangerous moment of the threat rule. And for years, courts went along. It begs the question, who controls the Fifth Circuit? Well, I've answered that already. There are 15 active judges. There are about 9 judges that are in senior status. And nearly all of those judges were appointed by GOP presidents. As I said, of the 15 active, 5 were appointed by Donald Trump. And they are very, very conservative and very, very supportive of the police. In their minds, the police can do no wrong. So they created this rule to protect almost anything the officer does. And the rule is so outrageous. I mean, the officer could have spent 10 minutes before he shot the victim, beating the victim for no reason, but none of that could have been considered or reviewed by the judges when they have to decide whether they should dismiss the case or whether they should not dismiss the case. They only could look at the moment the officer used deadly force until he stopped using deadly force. I mean, it's amazing. So these judges created this dangerous rule. And again, these judges, they see the world totally different than the way most of us see the world. They're more apt to protect actions, the type of actions that Officer Felix took in this matter, and they're more likely to dismiss lawsuits like Ms. Hughes. But God always has a ram in the bush. No pun intended. Always. And as a member of the clergy, I must always try to find the bright line. I must always try to find God in horrible circumstances. And that ram in the bush is a Fifth Circuit judge by the name of Patrick Higginbotham. Judge Higginbotham. He wrote some extremely important words in the Fifth Circuit opinion, because once the lower judge dismissed Ms. Hughes' lawsuit, it ended up with the Fifth Circuit, the circuit that had created the rule. But it just so happened that Judge Higginbotham had issue with the rule. He was bound by it, and he was one of the judges that had to support the dismissal of Ms. Hughes' lawsuit, but he wrote a concurrent opinion. He also wrote the majority opinion, but he took the unusual step of also writing the concurrent opinion where he heavily criticized the rule of his colleagues. So I want to take you to his opinion, and I want to read just a little bit of it. I think that this was just amazing for this, I think, Reagan-appointed judge to point out to his colleagues that the rule needed to go. So let's go. I want you to just read some of this with me. So here's Judge, let me pull it up, full stop. I want us to see it all. All right, Patrick E. Higginbotham, circuit judge, concurring. He said, a routine traffic stop has again ended in the death of an unarmed black man. And again, we cloak a police officer with qualified immunity, shielding his liability. The district court rightfully found that its reasonableness analysis under the Fourth Amendment was circumscribed to the precise moment at which Officer Felix decided to use deadly force against Barnes. I write separately to express my concern with this circuit's moment of threat doctrine, as it counters the Supreme Court's instruction to look to the totality of the circumstances when assessing the reasonableness of an officer's use of deadly force. Now watch what he says. He says, to these eyes, talking about his eyes, blinding an officer's role in bringing about the threat, precipitating the use of deadly force lessens the Fourth Amendment's protection of the American public. It devalues human life and frustrates the interests of the individual and of society in judicial determination of guilt and punishment. Tennessee v. Garner, the case I've talked to you about, stricture on the taking of a life only to protect one's life or the life of another is the baseline of the Supreme Court's later validation of pretextual stops in Wren versus the United States and in the following term, Maryland versus Wilson, allowing an officer without more than pretext to order the driver of the then lawfully stopped car to exit their vehicle, sound on their face but unforeseen in their future, came the reality that these cases brought fuel to a surge of deadly encounters between the police and civilians. And might I add, this involves African-American men, those deadly encounters, 5 times more than any other people in the country. This reality makes plain the wisdom of Garner's baseline and that it ought not be further redrawn by refusing to look to what? The totality of the circumstances when a stop leads to the taking of a life. That is quite remarkable. For a Fifth Circuit, Reagan-appointed, no doubt conservative Republican judge to come to that conclusion. He was basically begging SCOTUS to take this case and to change this hideous, vicious, deadly, dangerous rule. Well, unbelievably, the Supreme Court listened, and it agreed to hear Ms. Hughes' case. Keep in mind, SCOTUS can refuse to hear cases. But in this instance, It did the right thing, and it took this case. And again, just a couple of days ago, it handed down one of the biggest and best decisions about police deadly force shootings, I would say in about 4 decades. And guess what? The decision was unanimous. Unanimous. Miss Hughes won her case not only for her son, but for the country. She won it with a unanimous court. That means all of them, Thomas, Alito, Roberts, Kavanaugh, Gorsuch, Barrett, Sotomayor, obviously, Kagan, obviously, and Justice Jackson, they all agreed that judges must consider all the events leading up to a police shooting, not just the moment the officer used deadly force. Justice Kagan, she's the one who wrote the opinion, and she said, and I love it, she said that courts cannot put on, quote, chronological blinders, close quote. In other words, she said courts cannot put blinders on regarding the events leading up to the shooting and just consider the shooting. That leaves out so much information. And in this case, it left out the fact that the officer jumped onto the car, creating, as Judge Higginbotham said, his own threat. So this ruling from the court struck down the Fifth Circuit's awful moment of threat doctrine. And it brought the law back in line with the Tennessee v. Garner case. Again, which stands for the fact that officers, number one, should not shoot fleeing felons, even if they catch them in the act of committing a felon, if that felon is not a substantial risk of causing serious bodily injury or death to the officer or to someone else. And it also stands for the proposition that judges should look at the totality of the circumstances when they review police shootings. And this ruling is not restricted to the Fifth Circuit, here where I practice, but it's for the country. Wow, and bravo to the court. I got to give the court an applause. And to think that it was unanimous, that's amazing. All right, now, in the midst of all that good news and all that being said, don't think for a second that the war against deadly police encounters, the war against police officers killing innocent, unarmed black men is over. That war's not over. Don't be naive. That is not what I'm saying. Okay? That's not what I'm saying. Don't take that from this, especially when you consider the fact that the current president recently released an executive order promising to militarize and unleash cops. And just based on words he said last year on the campaign trail, most of that is going to be released in the African American community. So don't take from this case that the fight against deadly policing in black communities is over. It's not. And some of you even said you welcome these militarized cops. And I told you, you don't. You may until they start killing folks you love for no reason. So while the Supreme Court has slightly reopened the door to justice, Trump's executive order is going to slam it shut as he claims to be interested in public safety. And I told you also in the video I made about this executive order that violent crime has come down sharply in the last 30, 40 years. So we don't need militarized cops with qualified immunity. And Trump wants to give them prosecutorial immunity. We don't need that. So this fight is not over. And Trump also said in that executive order that those cops don't have to be considered about any sort of racial equity or fairness. In other words, just go into the communities ablazing. So while the Supreme Court said context matters, Trump said, no, I'm going to unleash militarized cops. Wow. So, why does Ashton's case matter? So Ashton is gone, and we celebrate the memory of that young 24-year-old young man. But his case changed the law of policing. And here's why it matters. It forces courts to look at the full story, which couldn't be more important when you have these militarized cops on the way. You can't just look at the moment the officer fired the bullet. Got to look at all of it. Why else does Ashton's case matter so much? Because it gives families like Miss Hughes a real chance to fight back. No one wants to be in Miss Hughes' situation. Son dead, and she's having to fight the system to get accountability and justice on behalf of her son. But at least now you have a new tool, one that should have been in place, but not here in the Fifth Circuit. The court has made clear it's the totality of the circumstances. And this also shows, Ashton's case shows how biased some judges, some court districts, some circuits are in these matters. And then it matters for other reasons, very, very important reasons. It reminds us that elections matters. Voting matters. Judges and justices matter. And the person who ends up in that office, like Trump, he put extremely right-wing conservative justices on SCOTUS and judges throughout the federal court system. And he has 4 more years to do the very same thing. And he's not doing that haphazardly. He's doing that with the help of organizations like the Federalist Society. There's a man named Leonard Leo who helps Trump with this sort of thing, who helps Trump put these kinds of judges and justices on these courts who are quite often anti-Black. The Heritage Foundation and other organizations. And why any Black person would help those people rig the court system like this is beyond common sense. It doesn't even take book knowledge, just common sense. Well, the reason they're doing it is because they're listening to pro-Black imposters tell them that elections don't matter, voting doesn't matter, who's on the court doesn't matter, so that they can help Trump get elected and reelected. We learned from this case that what took 2 seconds to take Ashton's life and change his family's life can take a decade to correct. Again, this shooting occurred back in 2016, April of 2016. And we just got the case that corrected this mess. So back to the hero in this case. The hero has to be Janice Hughes, Ashton's mother, as well as Judge Higginbotham. But the mother, Janice Hughes, she lost the most. She said that she keeps a teddy bear. And when she presses the teddy bear, she hears her son's voice teaching his little sister how to dance. That's the voice that she listens to, she said, when she can't sleep. That's the sound that reminds her why she fought so hard. That bear, that teddy bear, carries her son's voice. And now because of Ashton's voice and Miss Hughes's courage, his voice changed the law. Okay? So, going forward, qualified immunity, it still protects officers. Trump's executive order, it empowers or will empower. It is in the process of empowering those officers. But again, as I said earlier, we got just a little bit more. Just a little bit more to fight with. Okay? Now, I want to close with this. I read the Supreme Court opinion in this case. And although the decision was unanimous, still, our adversaries, they don't get tired of fighting. They don't sleep. They don't slumber. While we are doing whatever we're doing, line dancing, letting our boots down, shaking our fans, they're plotting, planning, and executing their plan to protect white supremacy. I said all that to say that Justice Brett Kavanaugh, a Trump appointee, on SCOTUS, he wrote a separate concurrent opinion. He said, yes, I agree that we got to look at the totality of the circumstances. But then he went on to talk about how cops face extraordinary dangers. He emphasized that you got to give cops room to make those split-second decisions. And he warned the judges against second-guessing cops too harshly. Again, he agreed with the majority, but his concurrent opinion could give lower courts a path to weaken the decision, especially conservative courts like the Fifth Circuit. So Justice Kavanaugh sent a subtle message, a subtle signal that says protect the officers, even while following this opinion. So, again, they don't stop fighting. And that's what we got to come to realize, and that's what we got to understand for the years ahead. Big thank you, again, to Ms. Hughes and to Judge Patrick Higginbotham and to the Supreme Court. I'm so glad that this deadly moment of force rule has been overturned. I am Reverend and Civil Rights Attorney Augustus Corbett. Thank you for watching this video. And remember, stay woke.